So the question is, what is a preliminary hearing? A preliminary hearing is what it sounds like. It's one of the first hearings in the judicial process. You need to request a preliminary hearing within 10 days of being arrested, otherwise you may lose your right to have one. There are mainly two reasons to have a preliminary hearing. The first is to reconsider your bond. Your bond at a prelim can go up, it can go down, or it can stay the same. The second reason to have a preliminary hearing is to determine if there's probable cause to continue to prosecute your case. Now, what is probable cause? Probable cause basically means did the police officer, the arresting officer, have a reasonable suspicion to believe that you've committed a crime? It's a very low standard of proof. It's much lower than the standard of proof that you would face at trial, which is beyond a reasonable doubt. 90 or more % of the time, probable cause is found in the case, and the case is what's called bound over, meaning the solicitor's office continues to prosecute the case. But a preliminary hearing can be a very valuable tool for your lawyer, because it's a good time for your lawyer to cross-examine the arresting officer. It's a good time to find out what are the strengths and weaknesses of the state's case. You're not allowed to present any evidence at a preliminary hearing. Basically, what normally happens is the arresting officer takes the stand, they read the warrant, and then your lawyer is allowed to ask questions or cross-examine the police officer. So you can't present any evidence, you can't testify. The only thing you can do is ask questions. But as I said, it can be very beneficial. You can get your bond lowered, and you can determine what the strengths and weaknesses are of the state's case. So it's important to hire somebody to have with you at this crucial period in the criminal justice process.